Good afternoon. I'm Jessica Berg. I'm one of the deans here at Case Western Reserve School of Law, and I'm very pleased to welcome you this afternoon for one of our Burke Environmental Law Center's signature lectures. We're very excited to hear the judge this evening. I'm going to turn it over to Professor Jonathan Adler, who's the director of the center, to do a more detailed introduction. And just so you know, we will follow with the reception. Although we normally do those in the rotunda, it will actually be upstairs in Ben's place, so just as an FYI. Thanks.
Thank you, Jessica, and thank you all for coming. As I think all of you know or may know, the Coleman P. Burke Center for Environmental Law was founded in 2019 with a gift from our late alumnus Coleman Burke to endow our program. We do lots of programs like this, and we're certainly thrilled that we can do them in person again. We are appreciative of Coleman Burke and his family's generosity that make programs like this possible, that make possible the scholarships we offer to students in environmental law and the various other programs that we do. Today, I'm really pleased and honored to be able to welcome Judge Margaret McKeown of the U.S. Court of Appeals for the Ninth Circuit to talk about her new book, make sure I'm picking up the right copy, Citizen Justice, The Environmental Legacy of William Douglas. Judge McKeown served on the Ninth Circuit, U.S. Court of Appeals for the Ninth Circuit beginning in 1998. Before appointment, she was the first female partner at Perkins Coie in Seattle and Washington, D.C. She holds a JD and an honorary doctorate from Georgetown University Law Center, was a White House Fellow, served as Special Assistant to the Secretary of the Interior and Special Assistant at the White House. She has served on a number of boards and conferences and committees, among other things, the U.S. Judicial Conference on Judicial Conduct and Disability Committee, was former chair of the U.S. Judicial Conference Codes of Conduct Committee, is a jurist in residence at the University of San Diego School of Law, and one thing that I just thought was particularly neat among her many honors and accolades, she was a recipient of the Girl Scouts Cool Woman Award. A Wyoming native, I think it's only natural that she took an interest in the legacy of Justice Douglas, his particular interest in environmental law and environmental advocacy. And as someone who has spent much of her career concerned with questions about judicial conduct and judicial ethics, it is also only natural that she took an interest in the citizen Justice Douglas, who was known both for his work on the court, but also his continued advocacy for environmental matters. And so here to talk about that book and her work on Justice Douglas, I'm really pleased to be able to welcome Judge Margaret McKeown.
Well, good afternoon, and thank you to Case Western for inviting me, and particularly for Professor Adler. And the chance to be here with your environmental program is particularly special. I've been to Cleveland before. I have not been to Case Western. I've been to many law schools, so I was actually thrilled to come here and spent this morning walking all over this amazing campus. We were driving in. Of course, I saw the Cleveland Clinic. I said to my husband, in case anything happens, I'm in good hands here because, of course, the Cleveland Clinic is quite famous. You know, William O. Douglas. Some of you have heard of him, maybe some of the law students less so, given your time in your career. But he's often called Wild Bill. Why is that? Well, first of all, because he had 4 wives. One of whom was 23-year-old when he was 67 and they got married. Another thing is that he was pretty much a rabble-rouser. Then Representative Ford tried to impeach him. That didn't work out happening. And there's a number of things in his life that I think kind of border on scandal. It might be kind of interesting to talk about, but I'm not really here to talk about those things. What I want to talk about is what I think of him as Wilderness Bill. And that is, he was a band leader for the conservation movement. He really pushed the envelope ethically, personally, and judicially. Interestingly, he's the longest serving justice ever, 1939 to 1975, 36 years. So he lived his life really on the edge. And I find him both fascinating but also flawed, and that's the story of my book. So before we get into his life and work, I want to tell you how the story came about. So it begins in Wyoming, not Washington, DC, I'm often asked, well, how did you end up writing this book? Really serendipity. I'm a Wyoming native, and I was snowshoeing out in Grand Teton National Park, and I came across, I think this will work. Yes, I came across this ranch, and I literally was standing on this roof with this snow trying to figure out, how do I come down from this? Where can I eat my lunch? And given property rights in Wyoming, you don't just go sit on somebody's front lawn, even if it's a snowbank. So I was kind of contemplating this, and a guy comes out of nowhere. It's the middle of winter. And I say, well, where am I? And he say, well, you're at the Muir Ranch. And so like a smart whatever, I say, of course. I know John Muir. And he says, no, not John Muir. The Muries, M-U-R-I-E. I said, oh, okay. So it turns out that from about 1945 until the early 60s, Olaus Murie, who lived at this ranch, was the head of the Wilderness Society. He was also a world-famous biologist, and his wife, Marty, who died at 101, was a naturalist, an author, and she was known as the grandmother of conservation, particularly for her work in Arctic Alaska. So I later discovered this letter in the Murie archives in which Justice Douglas writes to the Muries and said, I think you should give this ranch to the National Park Service so that they can use it as a place for conservation. I thought, well, that's pretty presumptuous. The Supreme Court Justice says here you should give away your homestead. But it did come to pass. And so there we have it now without the snow. And it is a National Historic District, just like the hotel where I'm staying. Glidden is a National Historic Place. But here's what kept nagging me. How is it that this justice, someone famous from Washington, D.C., meets up with these somewhat humble people from Wyoming? Well, it turns out they're all Westerners, of course. They're all connected to the land, and they're all committed to conservation advocacy. So I started my research totally on a lark. I went to the Douglas Papers in Washington, D.C., and then the Wilderness Society. And really, I wasn't intending to do much with it, but to have a little fun. And everyone said, well, you should write a book. I said, no, I write opinions. I am plenty busy writing opinions. Writing a book, I don't know. But you know what? The more archives I went to, and I was at the Library of Congress on many, many, many occasions, I discovered that there was really a larger story here. And it was one, or is one, that highlights Douglas's role as a leader in the post-World War II conservation movement. And he really illustrates for us that intersection between law and the environment. So let me set the stage for who he is. He's been called many things, as I say, a communist, frontier justice, Mr. Justice Pangloss. He always had this big hat that he wore. And he showed up in Washington, and as we say out west, some people thought, is he all hat and no cattle? Because is he just putting on a show? Well, turns out that no, he wasn't. He was born in Minnesota, but he came out to Washington, Yakima, at a very young age. He had a single mom. His father died very young, and she had one goal in life. She called him treasurer. Her goal, he should be president of the United States. So no pressure there. He was a smart kid. He was always rising to the top of his class. But he had all these bouts of illness. So he's kind of a skinny kid. He gets bullied. And what does he do? He goes out into the wilderness near Yakima, Washington, Cascade Mountains. And it was this mystique of him having polio that really drove who he is. And I think we see that a lot in his life. So he took this refuge in the mountains. And throughout life, he made this connection between spirituality and nature. So he goes off to Whitman College, and then rumor has it, and we've documented, he rode the rails to Columbia Law School. In fact, first actually working with a herd of sheep to get them to Chicago. And he chronicles this in an autobiography that many of us read as young students, Go East, Young Man. He marries a young teacher from Yakima. So he's now at Columbia Law School. He's on this totally meteoric rise. He's very at the top of his class, but he misses the brass ring, and that is, of course, the Supreme Court clerkship. He didn't get it, but here's the amazing thing. 14 years after he leaves Columbia, he's on the U.S. Supreme Court. So he didn't actually need the clerkship to make it to the Supreme Court. So before he goes on the court, in those 14 intervening years, he first goes to Cravath, Swaine, and Moore. And he thought it was pure drudgery in terms of the work. So he kind of toyed with maybe he should go back to Washington State. And he interviewed with my former law firm, Perkins Coie. They offered him $600. Cravath said $5,000. So of course, he ran back to New York. And he decided, well, the money didn't make any difference. It was no more interesting at that price than it was earlier. And he was never really meant to practice law, I think. So he became a law professor. First he's at Columbia and then at Yale. And with all respect to those of you in the academy, he said, the problem with the academy is that the professors are always asking questions, but they never answer any questions. So he's there in that time period of, legal realism, and he wants to make law more relevant to life. He's studying business reorganization. So keep that in mind. This guy is a business lawyer. And he does a study on bankruptcies, business reorganizations. It catches the attention of none other than Joe Kennedy. So he goes down to Washington. The SEC is newly formed. And before long, he's not doing a research project. He is an SEC commissioner. And then another couple of years go by, and he's the chair of the SEC, which is really pretty remarkable for someone his age. So then he gets appointed Supreme Court. Second youngest justice to serve both then and now. He's 40 years old. Now, if you go back in time, Roosevelt wanted a Westerner on the court because much like today, most everybody is from the East. So Douglas tried to portray himself as a Westerner, but he'd spent most of his adult life now on the East Coast. So Roosevelt calls him in, and he knows he's going to get some appointment. He's afraid it's going to be the chair of the Federal Communications Commission, and he was not excited. So then Roosevelt says to him, I'm going to give you a job that's like going to jail. In which case, he says, I knew it would be the FCC. And amazingly, Roosevelt, backed by Brandeis, whose he was succeeding to, said he wants him to be on the U.S. Supreme Court. So Douglas, I don't think he was totally surprised. Although he has a way of kind of exaggerating things like, oh, what a surprise, he wants me to be on the U.S. Supreme Court. Well, he was working the political levers behind the scene. Because although, he'd been the skinny kid and bullied, by the time he gets to D.C., he's getting pretty confident. And he was a real political animal. He loved the Washington environment. He went to all the parties, at the embassies. He played poker way into the night with Roosevelt and advised Roosevelt on all manner of things, as we know a number of other justices did as well, for example, Frankfurter. So he soon becomes kind of part of the political and social fabric. First decade on the bench, his political star is continuing to rise. Now keep in mind, he's in the Supreme Court, the third branch. He's not in the political branch. But for almost 10 years, his name is floating about as a possible presidential candidate or vice presidential candidate. So when Roosevelt is going to choose a vice president, rumor has it there's a little piece of paper, and none of us have seen that piece of paper. It doesn't seem to be in any archives. And it either says Truman Douglas or Douglas Truman. We don't know. But what we do know is in the end that Roosevelt chooses Truman. And then sadly, of course, Roosevelt dies, a big blow to Douglas because he views Roosevelt almost like a father figure. And he's still kind of in the political stream. Then we come to what I think is really the true last push, 1948. Truman is president. He needs a vice president. And he asks Douglas to be the vice president. Douglas turns him down and he says, why be number two to a number two? So that gives you some flavor of Douglas's personality, actually. And he said no. He said, no, politics are perishable. The work of the court is long and enduring. I'm going to stay here. And it turns out, as his political prospects plummet, I think his allegiance to the court, gets stronger and stronger. But I was looking for what I thought was, why did he all of a sudden shift from this political side to being a conservation advocate? So in the late 40s, he had a ranch cabin, really, I should call it, out in Washington State. And he's riding his horse, and 1,600 pounds of that horse, wham, rolls right down on him. It was remarkable he wasn't killed. He broke 23 ribs. I didn't know he had 23 ribs, but he broke all those 23. He spared one. And so he starts to recover. And he took some time away from the court, obviously, to do that. And as he's recovering, he writes the first of his autobiographical trilogy of Men and Mountains. And it's a very flowery book, an homage to the mountains and to the wilderness. And around this time, I think he really had, all of a sudden, this unapologetic enthusiasm and activism. Frankly, his marriage to wife number one was somewhat on the rocks. He's a little bit bored at the court. He's only been there 10 years. And he's now looking kind of for a shift. So he, I think, pinpoints that to some degree to a case called O'Malley v. Woodruff. And here's the question for the Supreme Court. Should federal judges pay income tax? I see a few federal judges here. We wish the answer was no. But of course, the obvious answer is yes. Judges should pay income tax. They quickly asked that judge's question. And they said, you have to pay income tax. And he later tells Eric Severide, when I voted on that case, he said, young man, you voted yourself first-class citizenship. And so here's what he says to Eric Severide. Basically, he says, well, if I'm going to be a citizen like everybody else, I should be able to do what everybody else can do, unless it interferes with the work of the court. And that's really somewhat the focus of my book is, well, does what he was doing interfere with the work of the court? While he's on the court, he really has kind of two abiding themes. Number one, he says wilderness needs to be saved. And he connected the individual to this larger environment. Once wilderness is lost, you can never get it back. And second, and this is a theme you'll see in a lot of his opinions, he believed that the role of the Constitution was intended to get the government off the backs of little people and to protect minority rights. So those themes, I think, are both in his conservation work and also in his Supreme Court opinions. So I want to talk a couple of ways about how I see him as a dissenter. I think he first embraced this idea of being I am a citizen justice to what I call dissenting on the road. When he was growing up, he had a lot of heroes, ones that we are familiar with. Thoreau, John Muir, Teddy Roosevelt. And that devotion, I think, really came through full force on his first famous hike, the C&O Canal. Here's the calendar entry for the day. It says hike. And one of the beautiful things about the archives, you can go and you can see all of his opinions in longhand on yellow pads. You can look through each day of his diary, see what was he doing that day or what he admitted he was doing that particular day. But I would say that this day, March 20, 1954, was really totally changed the trajectory of his life. So the Park Service, has anybody here been to the C&O Canal in Washington, D.C.? Okay. So Park Service wants to build a highway down to the canal because then people can get there easier. And in fact, that was a tension he had with Roosevelt, who was disabled and had trouble getting places. He said, look, if you close everything off to people, how will people like me get places? Douglas says, well, there's a lot of places you can go, but we need to save wilderness. So the Washington Post was in favor of the highway. Douglas is outraged, and on Supreme Court stationery, U.S. Supreme Court Justice, he writes an editorial to the Post, and he says, you're wrong. This is a sanctuary, it's a beautiful place. You should not build a highway. And to show you this, I want you to come hike with me. So that's what he did. There he is, he hikes the canal. It's 189 miles long, took him 7 days, snow, rain. Only 9 people finish. One of those people is Olaus Murie, back to the Murie Ranch in Wyoming. And that's where he meets the Muries. Now, Douglas is incredibly tall and fit. He was a fast hiker, 5 to 6 miles an hour. If you were hikers, that's a lot. And for a short person like me to try to keep up with someone like Justice Douglas would probably have been impossible. But guess what? He convinced them. And so there he is shaking hands with people. He arranged for the Secretary of Interior to be there, big publicity. And the Post revoked their endorsement. So then Douglas embarks on a lobbying effort. He creates an organization, he's the chair, of course, and they start lobbying the Park Service, the President, Congress, and eventually, in 1971, this becomes a National Historic Park. And they say it's the only national park walked into existence. So if you're ever in Georgetown, just below the main shopping fair on M Street, there's a bust of Douglas celebrating what he did. But now I think, he's basically on a roll. So the Muries are going to go on a true scientific expedition sponsored by the New York Zoological Society to Alaska. And they invite Douglas to come. So they have food like, Jell-O and canned corned beef and that sort of thing. So Douglas goes up there. You can see Marty Murie there. She's got that kind of plaid shirt on. She really is like a caricature of herself. She's this wonderful grandmotherly lady. And she keeps saying, Mr. Justice Douglas, do you want some coffee? Do you want some cocoa? And he goes, no, call me Bill. So it's like he had this life around the campfire. He's just another camper. When they leave there, now the Muries were very committed to the Arctic. They'd gone on their honeymoon there in a dog sled. And they were worried about the fragile environment in the Arctic, something that to today is in the news and is debated. So Douglas goes back and he does 2 things. He writes a chapter in his book, My Wilderness of Pacific West, and he talks about the Arctic. And at the same time, he's back in Washington pulling a few levers. It's been said that negotiating with Douglas is kind of like shaving with a blowtorch. So the guy is very strong and aggressive. But after decades of being a political football, the Arctic, it is actually put into Arctic Refuge protection. And in 1980, the Alaska National Lands Interest Conservation Act, quite a mouthful, ANILCA comes to pass, and millions of acres are protected. So now we've got the Sino Canal, we've got Alaska, and the Douglases and Muries are talking again. What should we do now? So highway, big issue, of course, in the 50s, all over the country, because we're coming out of the Depression, we're coming out of World War II, and America wants to expand. So we all recall, this glory days of the National Highway System. So now Douglas organizes a protest hike in the Olympic Beach, which is where, out in Washington State, it's the last unprotected piece of unused, untrammeled coastline. And Douglas says, this is a place of haunting beauty and solitude. And then he says what he often says, this needs friends. So there's only 22 miles this time, and women were included. They weren't included on the CNO hike. So I want to give you a sense. There he is on the beach. And if we can get the film to work. See how tall he is? Look at the backpacks.
This was a height to remember. You might say our whole nation was involved, for something was at stake that concerns you and me and our children, and the children of our children. You might say, too, that it began in our nation's capital, because the idea for such a hike started with William O. Douglas of the United States Supreme Court. This is Justice Douglas coming down the steps of the Supreme Court building to meet some other people who were going along on the hike.
There's Olaus Murie with the beret, and they're also there with Howard Zahniser, who is considered to be the architect of the 1964 Wilderness Act. So as it turns out, that highway was never built, and Douglas said, why not put it behind the beach? I mean, why do you have to put it down the beach? So you can go there now, and there's 22 miles, no hot dog stand, no cars, not even a highway. And the highway was built back from the beach. So another way that he dissented is in the corridors of power. That's a different kind of advocacy than sort of on his feet and out there protesting. So to me, maybe the biggest surprise in researching the book was the extensive lobbying he undertook on behalf of the environment, projects all over the country. In my view, he kind of becomes a one-man lobby shop. So here's his approach. You saw it in the others. He finds a threatened place. He leverages local and national groups. He forms a committee. He's the chair. And he starts to lobby Congress or whomever. So it's really, he's a pretty unusual justice. And I think it's hard to imagine today any of today's justices, you know, let's say Justice, you fill in the blank, leading a protest hike like Justice Douglas did. So again, I, in doing the research, was kind of combining my view, a lens of a judicial perspective, but also from an ethics perspective. And I spent so many years on the Federal Judicial Ethics Committee, and so that was really interesting part of this. So I take this liberty, I made him up a little business card here. It's not really his business card, but I say he's a supreme conservation advocate, and that's really true. The question, you know, how diffuse his work was. One day he could be on a national park coalition in Maine, then he might be on a logging project in Oregon, a dam in Washington State, sagebrush in Wyoming, the scrub out in Texas, a river in Arkansas, a pond in New Jersey, you name it, the list goes on and on and on. So let's start at the top. He has a very close relationship both with President Kennedy and with LBJ. He once told President Kennedy, the trouble with you, Jack, is you never slept on the ground. Which was true because the Kennedys were kind of these blue bloods from the East Coast. But Jack Kennedy said, take Bobby to Russia, take Bobby mountain climbing, which he did. But of course, there's not many years that Kennedy is there as president. And then in comes Johnson. And he was very close. Johnson is the one who signed the Wilderness Act. But they had kind of an uneasy relationship because Douglas kind of thought Johnson was a fraud, a politician in terms of the environment, but actually Johnson had done quite a bit. At one point, Douglas writes a book called Farewell to Texas. And it was about oil and gas and other industries in Texas. And Mrs. Johnson was totally infuriated. He had a much better relationship with Lady Bird. She said, change that title. That is a disgrace. That is not fair to Texas. He did not change the title. So Farewell to Texas is one example. But he was jawboning with Johnson all the time. He might go on a protest hike, and then he'd write a note to Johnson that says, Dear Lyndon, I think you might want to study or have your Interior Department study such and such an issue. And we know that's really a recipe for put it on the shelf in Washington, nothing will happen for a while. But he wasn't shy about going to the top. He wasn't shy about going to Congress, and he wasn't shy about, going to the agencies. So here's the interesting thing about that. He has a public enemies list, and he says, well, it's not easy to pick out the number one enemy. But your eyes are probably going to well, what publication was that in? Playboy magazine. Oh, wow. Why is he writing in Playboy? Well, he says that's because what young men read is Playboy. And I want to reach everybody. Okay, so his number one enemy was the Army Corps of Engineers, which of course is the agency responsible for flood control, or as Douglas would say, the public be damned, because of course they put up various dams. He used to love the Forest Service and Gifford Pinchot, but then he said, you know what, they're just cut. So he went off loving the Forest Service, and he was even pretty critical of his great friends at the National Park Service. Although he and Stuart Udall, who had been the Secretary of Interior for 8 years, they really had a close relationship, even when Udall intervened in some of the Supreme Court cases. So before I leave this idea of him really dissenting in the corridors of power, I do want to talk about him as an author and a writer, because writing was a really key plank of his advocacy. One biographer said he was a national teacher for all of us. He was a very fast and prolific writer. He wrote 50 books, so it's basically like a book a year, which is pretty phenomenal starting in the 40s. He had hundreds of articles, but it's not just Playboy. He also wanted to reach what he called America's housewives, who he felt would really understand the need and the importance. So he was also writing for women's magazines, like Red Book, Ladies' Home Journal, etc. He wrote for National Geographic, National Enquirer. I have a theory that part of this was he had a lot of alimony coming from these marriages, and public justices, even the Supreme Court, are not paid the highest salary, and he needed a little extra cash. And back then, they actually paid you to write in these magazines. Now I think you have to practically beg them. It's like asking to be in a law review or something. So, he was paid to write. And he just wrote these amazing books, everything from books on Tibet, you name it. If you remember that movie, Rear Window, and you look really carefully at the end, you'll see Grace Kelly. And she's reading a book called Beyond the High Himalayas by William O. Douglas. So, he was on TV, he was in books, he was on radio, a very unusual justice. We now see the justices somewhat more on TV. We see a lot of autobiographies, but back then that was really very unusual. So basically he's invoking the prestige of the court to stop federal projects and extol the virtues of wilderness. But you also have to think back in time. America's in the 50s, the 60s, and 70s, and that's really when the environmental conscience is being ignited. I don't think you can leave this topic, though, without talking about him on the court, dissenting on the court. Remember, as a kid, he's skinny, he wants to fit in. Well, by the time he gets to the court, he seems to have lost kind of that fear and that naivete, and he has now a real confidence. He is a champion dissenter. He's maybe too sure of himself. By the time he retired, he dissented in almost 500 cases. Now, when I think of champion dissenters, I do think of Justice Stevens, who succeeded his seat, but really also Justice Scalia. He was on the court 30 years, he had only dissented maybe 200 and some times in his time on the court. The curious thing about Douglas is this: in his dissents, in a whopping 40% of them, he is the only dissenter. So that says something. And of course, he's on there for so long, nobody can match his record unless one of them lives out and is there longer than 36 years, but they'll never reach his record because now the court is taking, 60 cases a year, and they used to take, a couple hundred a year. So no other justice has matched his record. But he didn't aim for consensus. And he once said, the only soul I have to say it is my own. So I think, given his intellect, and several people, including Brennan, said he's probably the only genius they ever met. He never really used that to coalesce the court, and I think that he lost a lot of his intellectual power as a result of that, to sort of go it alone. He did have, of course, a number of famous majority opinions. One in the news now, Griswold v. Connecticut, 7-2 decision on the right to privacy. He was an incredible workaholic. He did everything kind of to the max. He hiked fast, he worked fast. He said his job only takes him 3 or 4 days a week. So you can imagine what the other justices thought of that. One of my colleagues, who had been at the court at the time, said a lot of the things he wrote were called airplane specials. And why was that? Well, he comes to the end of the term, at the end of June. He's written his majority. He's written his dissents. Why do you need to wait around for anybody else? So he jumps on the airplane and goes out to Washington State, where he has a cabin very near where he grew up. And that cabin is kind of famous because, in the old days, even when I was practicing law, if you had a matter before the Supreme Court and you wanted an emergency petition, you could present it to one justice, and that was the justice assigned to your circuit. Douglas was assigned to the Ninth Circuit. They try to do it somewhat geographically, but can't really keep that these days. So there's articles about people, lawyers hiking out to Goose Prairie, and they're all dressed up with suits and ties and everything. Douglas says, that is ridiculous. That is not what you wear in the wilderness. And they go, well, Mr. Justice Douglas, we have this petition, we want to stop the Vietnam War, or we want to do this, we want to do that. So one of the famous ones is he says, come back tomorrow, I'll put that petition, I'll look at it and I'll give you an answer. So he puts it under the rock, and of course, petition denied. He did stop the Vietnam War for like a nanosecond before the rest of the court kind of came on. But that's who he was. He was kind of a chief dissenter. He's an individualist, he's a loner. And I think about when he talked about hiking, he said how lonely had been the trail I walked. And I thought, well, he could have been describing his life on the Supreme Court. Although he was friends with Blackmun and Black, he just staked out a position, and he didn't jawbone, the other justices particularly. So last year, 2022, was the 50th anniversary of Sierra Club v. Morton. And so even if people don't know who Justice Douglas was or is, they do remember that landmark standing case from law school. So I want to talk somewhat about it because it is considered one of the most famous dissents in Supreme Court jurisprudence, and certainly in the environmental and standing area. So how do we start? Here we are. This is Mineral-King Valley out in California. Beautiful valley, and Walt Disney wants to build a ski resort there. But to build a ski resort, you've got to put in a highway, you've got to get people there. Then you've got to build all the paraphernalia and apparatus of a ski resort. Sierra Club is outraged, so they sue. And the district court in San Francisco temporarily said, stop the project. They quickly appealed to the Ninth Circuit. The Ninth Circuit says, no injunction against the project. And so then they go to the U.S. Supreme Court. But here's the interesting thing, is the Sierra Club, through a young lawyer, rolled the dice. They had seen various opinions that said you can have standing for aesthetic values. In fact, the first time they used the word environmental in the Supreme Court was not until the 1970s. And of course, it was Douglas who used it. But they decided, well, why not sue kind of in the name of this valley and the rivers and the mountain? So they do that. And of course, when they get to the Ninth Circuit, the Ninth Circuit says, no, you don't really have standing, the river, the valley, the whatever. So they go to the Supreme Court, and they don't really fare all that better there. But here's the interesting thing. Douglas is no stranger to the Sierra Club. He's been on their board 10 years earlier. He got off it because he said he was bored with being on a board, and I do believe that. He had protested with them not long before he's on this case, and they made him a life member. So he remained a member until late 1970. Out of the blue, he writes to the Sierra Club, "Hello, I don't want to be disqualified, just in case a Sierra Club type case could come to my court. I'm not thinking of any case in particular." Well, that is totally disingenuous, because by then, the cert petition has been filed, cert's been accepted, and I go through in the book what I thought was a major discovery is putting all the documents together between the Sierra Club and also between the University of Southern California Law Review, where a professor had bootlegged to Douglas an article on whether trees have standing. So all of that comes together, and there's a lot of gossip around the court. I interviewed almost every living clerk of Douglas, and with some related justices, and they said, "Oh yeah, there was gossip. Should he recuse?" Well, we know he didn't recuse. So when Potter Stewart, who wrote the majority opinion, he says they lack standing because there's no allegation of injury to the club or any of its members by this resort. So Douglas writes a passionate dissent, and it is one of the most famous. In his view, the case shouldn't have been called Sierra Club v. Morton. It should have been Mineral King v. Morton. And so here's an excerpt from his dissent. He talks about inanimate objects shouldn't be stilled. He talks about the priceless natural objects such as valleys, alpine meadows, etc. And really this dissent draws on decades of who Douglas is and his communion with the nature, his engagement with the conservation movement. And he literally writes this in a couple hours. He gets off the bench, he writes it, and then he says to one of his law clerks, who is now Judge also, Northern District of California, he says, "Here, fill it in with footnotes," which is not the way we normally go, at least I don't go about it that way normally. As you're trying to work together with data and with support, etc. So Alsop says, well, it's not so easy because like several paragraphs just excoriate the Forest Service. So where do you get that? Well, you could cite Douglas. He would be one of the, So Alsop does his best, and he sticks in a lot of footnotes best he can. And we end up then with this. Case eventually goes back to the district court, and after much foot dragging and environmental review, etc., Disney abandons the project. So if you go out to Mineral King now, you'll see that. So in the end, it was the spawning of what's known as nature's rights, standing for inanimate objects. And it wasn't just an academic exercise. It has not gained foothold, however, in the federal courts of the United States. But a number of municipalities actually passed laws giving standing rights, for example, to a river, or most recently to whales out in Washington State. Other countries have put it in their constitution, Ecuador, Uganda, Colombia, and New Zealand actually has a pact with the Maoris with respect to a river and a mountain. So he was pushing the envelope, but not entirely futile, because he's looking for the long run. Finally, I'll say he was dissenting in his own backyard all the time. There's his cabin at Goose Prairie. There's his wife, Kathy. There they are near their cabin. And then the upper is a picture of him with two women called the Blister Sisters. Actually, they're called the Double K Girls. They own a ranch next to him. And they're called the Blister Sisters because they would go after the Forest Service just like Douglas. And they lobbied together with Douglas in a number of things. For example, he had early efforts in Oregon. He wanted to stop a Kennecott copper mine in Washington State. He wanted to stop dams. And then he lobbied relentlessly to save this area north of his cabin in the Cascade Mountains. And eventually, it becomes the William O. Douglas Wilderness. So if you happen to be out there, and you're more likely to be in Washington at the C&O Canal, but all of us would love to take you on a hike, there you'll see this amazing picture of Mount Rainier, this amazing view. He could see that from his house as a little kid. So eventually, he worked very closely with Washington's two famous senators, Magnuson and Jackson, sometimes called the Twin Towers of Power. But it was two Republican senators in some later years, in 1984, that brought it across the line, praised him profusely, and we now have the William O. Douglas Wilderness Area. So in closing, I clearly view Douglas as an imperfect hero. And I think he teaches us the value of both being and the risks of being a contrarian. So by all accounts, he was a difficult personality, although his wife didn't think so, and many of his friends. And sometimes to his law clerks, he was an impossible tyrant. I mean, you can read example after example. One time he thought a law clerk wrote in one of the, Fed whatever, or U.S. Supreme Court, and he took the book and he threw it out the window of the Supreme Court. Well, they're up a couple stories in those offices, and he could have killed somebody, but he was so mad. And then he would turn around and be gentle and endearing. He did have an astonishing legacy, though, I think, in law, in the environment, and also in the lives of the people who knew him. A lot of clerks do remember him fondly. They went hiking with him on the St. Canal. They had whiskey with him, after work on Fridays. And in the conservation movement, he was treated with reverence. So it's like he had this white life at the court and in political Washington, and then he had this second life on the trail. And I think that he was a justice on a mission, there's no doubt about it. He once told his law clerks, get out in the stream of history, swim as fast as you can. And I think that's what he was doing. And he took his own advice, and he teaches us then this value and hazards of being a contrarian and of dissent. I don't think we can overstate his conservation legacy. So there's little doubt that this commitment that he had and his connection to the land had this enormous impact on the actual physical landscape in the United States. In a way, he was a climate canary on everything from pesticides to pollution to dams. And most importantly, what I think he did is he laid the groundwork with the conservation movements about what we now have as a modern day conversation about the environment. When he retired, which was somewhat reluctantly, he wrote this farewell note to his colleagues. He said that being on the court was like being in the wilderness. When you arrive, you're strangers, and when you leave, you're fast friends. And he hoped that the justices would leave these wildernesses and these watercourses as pure and unpolluted as those which we traversed. He told the law clerks, keep the faith in the rule of law. And here's what he wanted to be remembered for. Someone who made the earth more beautiful than when he came, and he definitely did. So I just will close with the last paragraph of the book. Douglas was a legal giant, a genius, a conservation hero, and a public philosopher. He always said he was talking to the next generation. And were he to look back on this remarkable journey, Douglas would despair at the environmental challenges facing the planet today, but he would delight that his relentless faith and intervention did leave the earth more beautiful than when he came. Many rivers are running free, choice pieces of wilderness are preserved, and the trees are still standing. So I appreciate you taking the time to hear the Douglas story, and I'll take your questions. So thank you.
We have time for a few questions, and then, as Dean Berg mentioned, we hope you'll join us upstairs for a reception in Ben's Place, where there are also copies of the book for sale, and I know that Judge McKeown will be happy to sign copies up there as well. But I always have tons of questions, but I'm sure Jeff has one, or if other folks have them, I'm happy to, folks, if they're
Does the
wait for the mic. Thank you.
Does the Supreme Court currently have ethical restrictions that would have prohibited many of Justice Douglas's actions? And if not, should they?
I'll answer the first part, and the second part I leave to Chief Justice Roberts and to others at the court. Well, there are a couple of things that I think reporters always overlook, and that is when we take an oath as a federal judge. There's an oath to be fair and just. And secondly, we have a statute, 28 U.S.C. 455, which applies to both judges and justices, so that's the language, that basically is making sure that there is also, you regard an appearance of impropriety. So those are in place. Is there a formal code? The Chief Justice says they do have one. Internally, they've also said that they follow the code for lower federal court judges. That's all of us here in this room. So beyond that, stand by. There's a lot in the press about that. But I do think he was a product partly of his time, because you had a lot of justices advising the president on the war. We have Justice Jackson, who everybody reveres. I mean, he went to Nuremberg, as a prosecutor. Takes a leave from the Supreme Court and goes to be a prosecutor. So there was a lot of it was of the moment. But I will say there never had been before or since someone like Justice Douglas.
Thanks for your talk. I just have a question about, can you speak to the, so Douglas and also Black, they criticized the court for acknowledging corporations as persons. Mm-hmm. I think Black from a case in the 30s, and then Douglas in the 40s. And as I understand it, considering nature's rights, the legal fiction of that was kind of like a counterpoint to the legal fiction of the corporation as persons from the 1886 case, Santa Clara. So can you speak to that?
Sure. No, thank you for your broad knowledge of that, because you're exactly right. They were critical about a corporation as a person, but then Douglas is quite clear in his dissent in Sierra Club that there are inanimate objects and beings, whatever you want to call them, that have standing. Corporations, ships is another good example. So he talks about that, and he's basically saying, if a corporation can have standing in its situation, why not a river, whatever. So he has a point there, although over the years it's been pretty well entrenched in our jurisprudence that corporations are different, corporations have standing, and we've had a lot of cases in civil rights and other areas that try to delve into, well, when is a corporation a person? What does it say in the statute? Or how is something defined in a statute? So there's been, continuing discussion on that. So I think it'd be interesting to come back in about 40 years and see if any progress has been made on the rights of nature and what he was writing for the future. He always said, well, now is a future, but 40, 50 years from now is another future.
You. So you mentioned about how he kind of had these two views of protecting minorities and low government interference. So I was just wondering how that shaped his thoughts on the creation of the EPA and all these government regulations surrounding the environment, just as they kind of increase government oversight in that area.
Right. Well, you might think because he'd been at the SEC that he would have been somebody that would give deference to administrative agencies, but in fact he did not, which was interesting. So, a lot of times he's called a liberal. I wouldn't always characterize him how people think of this kind of liberal-conservative dichotomy, particularly in that area. So he didn't think we should always give deference to agencies, which is kind of interesting. 'Cause he'd been in one, and he knew. And he also thought that a lot of times the agencies became entrenched. So you could take some of his rhetoric and you could move it to today's argument that we're having about deference and Chevron, et cetera, and Douglas would be right in there. And that's what's sort of interesting about him is that he's not always completely easy to categorize. He just went to his own drummer, basically, you know. So.
Those who some may remember that from administrative law. I have a question about standing. He's remembered for his dissent in Sierra Club versus Morton. He also wrote the majority opinion in Association of Data Processors,
Yes.
which is the origin, well, attributed by some of the origin of the injury in fact test, initially with the idea of expanding standing to sue administrative agencies, but since then, certainly since Lujan versus Defenders of Wildlife, has been the basis for narrowing when people can sue administrative agencies. And I was curious if you had thoughts about his role in writing that opinion, any thoughts about what he was trying to accomplish in Association of Data Processors beyond what he did in environmental cases like Sierra Club versus Morton.
Right, if you look in the Sierra Club papers and even in his own, when they're considering Association of Data Processors, ADP, he's thinking exactly about that as expanding standing. And the same thing was true, there were two cases, scrap, I can remember the students, you know, two scrap cases where he does the same thing. So in a way, he wants to, by and large, he wants to expand access to the courts. But he also has this internal regulator, I guess, if you will, about administrative agencies. So I think that in some ways, Sierra Club v. Morton is just a progression of where he's going on the standing issues. I, not so long ago, wrote a very short article about how, you know, we went along that route and then boom, there came Lujan. And now all of a sudden, we are restricting access to the federal courts in so many ways. And Lujan was just one of many opinions that we see where the large courts and lower courts have been restricting access. So I think he would have jumped out at the window. He wouldn't have thrown the book. He would have jumped out the window in reading Lujan, I think, and given, you know, how excited he would get about these things. So, you know, he really did start us down a path on standing that came to a halt. And it would have been sort of fun to see Justice Douglas and Justice Scalia on the same court.
Well, on that note, thinking about what the court would be like if Justice Douglas and Justice Scalia served together, please join me in thanking Judge McKeown for remarks today. Join us upstairs at Ben's place for a reception and a book signing. Again, there will be books available for purchase up there, so please join us for that. And if you need the CLE, certainly return the CLE forms to Patty Arbold so we can make sure you get them.
Thank you. I should just say I have one unusual thing in the book, and that's a recipe, because Marty Murray had front porch conversations, and she tried to bring competing views in conservation and other things together on her front porch. So she made these cookies called Crybaby Cookies, and I thought, why not put that in the book? And the publisher said, well, that's a little unusual. I said, well, it is my book. So I have a recipe in there as well. But thank you for coming.